Good afternoon, everyone. I want to thank everyone for attending today's webinar to hear about some proposals this office is considering and learn about upcoming meetings where we welcome public comment on these proposals. My name is David Augustine. I'm the tax collector for the City and County of San Francisco, and I'm joined here by my colleague, Greg Cotto, the Director of Compliance in this office. Before we begin, I'd like to review a few housekeeping items. Today's webinar is being recorded and will be posted on this office's website at a later date. The public comment component at the conclusion of the webinar will not be recorded, and the future feedback sessions will also not be recorded. By default, all participants will be muted and video is disabled. At the conclusion of each section, I will ask participants to use the raised hand feature and will unmute one person at a time and listen to any comments from the community as time permits. These comments will be recorded. At any time during the webinar, you can provide comment in the Q&A section by selecting the Q&A button at the bottom of your screen. There will likely not be a great deal of time for public comment today, but please be aware that the purpose of the upcoming feedback sessions on September 11th, September 25th, and October 9th are designed to hear from members of the public and the business community.
Going on to slide 3, we will be encouraging members of the public and business community to submit written comments. Comments may be sent to taxreform at 2024@sfgov.org. Please note that any comments sent in response to this request are generally going to be considered confidential taxpayer information under Business and Tax Regulations Code, Article 6, Section 6.22-1. Although this office may anonymize certain comments or suggestions to the extent useful to share with the broader public. We also encourage comments, both written and verbal, on ideas discussed in these sessions after they are concluded, and feedback can be anonymous as well.
The purpose of the sessions, why are we here today? So first of all, these sessions are different than the more formal rulemaking sessions we generally hold. This is not a hearing and will not result directly in new rules or programs. It is informal, designed to facilitate discussion, and purposefully so. We want your honest feedback, which sometimes can be difficult to give to the tax authorities, we know. We are pleased to engage with the business community on these topics. Your feedback will undoubtedly make these programs better. We've learned a great deal through the past year and the various meetings about business tax reform, and we've appreciated hearing many viewpoints about what matters to San Francisco businesses and residents. We want to continue these types of conversations and encourage you to keep communicating with our office on ideas and initiatives even after this process concludes. We know taxes can be complicated and deeply impact the business experience in San Francisco. These programs we are looking into would hopefully allow for more certainty about tax outcomes for our businesses, which we hope is a shared goal. And we are always open to ideas for how to work better with businesses to make sure that taxes are fair, known, and administrable. It's important to note that today's webinar and the future meetings in September and October on all topics are for discussion purposes only, and nothing said in these meetings reflects a policy position of this office. For all the proposals under consideration, if they move forward, they will require some type of rulemaking process in order to effectuate them as official policy. For instance, sourcing rules would likely be subject to a tax collector regulation process. These meetings are an important opportunity for us to share information, discuss different opinions, and ultimately craft policies that work for the city and for taxpayers.
All right, I'm going to go over a little bit about today's meeting and our future meetings. For today's meeting, we are going to present information about 2 proposals that the office is considering implementing, as well as present questions related to sourcing that we are seeking feedback on. First, we have a voluntary disclosure agreement proposal. This would be a program to provide voluntary disclosure agreements to taxpayers who have a San Francisco tax liability, but have never filed or paid taxes or been contacted by this office. Second, we have an advanced written determination proposal. This would be a program to provide advanced written determinations to taxpayers who seek advice on specific facts and circumstances related to apportionment and business activity classification questions. Finally, we are seeking feedback on questions related to sourcing. In order to create regulations for sourcing, our office created a set of questions that were sent out to all interested parties as of July 23rd this year. We anticipate collecting feedback and having additional meetings on sourcing before developing specific proposals to review. Again, written comments received on this topic will be treated as confidential taxpayer communications. We anticipate there will be a good amount of feedback on the sourcing questions, and feedback on these questions is important to our office. Therefore, we anticipate allocating the bulk of future meetings to feedback on sourcing questions. In order to help people plan for the meetings that are most useful to them, we will be listening to feedback on the voluntary disclosure agreements and advanced written determinations on September 11th. September 25th will be focused on sourcing of intangible property and financial instruments. And October 9th will be focused on sourcing services and any continued discussion of intangible property and financial instruments to the extent we need.
Okay, the first program proposal, and we'll stop for a little bit of comment at the conclusion of this proposal. It's a voluntary disclosure agreement proposal, and I'll call it a VDA because we love our acronyms here. The VDA program would be authorized by legislation for a 3-year period. The VDA would provide relief of penalties, but not interest, to any taxpayer who applies to and is accepted into the program and timely files and pays back taxes for the 6-year look-back period from the date of application. The VDAs would be available to any person who has not registered as a business in San Francisco, has not filed taxes, and has not been contacted by this office. If a business has been contacted, has filed, or has previously registered, the taxpayer would not be eligible for the program. All tax types are eligible, including third-party taxes, such as the transient occupancy tax and parking tax, as long as taxes have never been filed. New members of combined groups are considered eligible despite the filer or other members not being eligible. The taxpayer would file and pay for up to 6 years of back taxes in any tax type in order to satisfy the VDA. TTX may require records to validate information provided by the applicant. The taxpayer's VDA application may be anonymous or through a representative. However, the taxpayer must eventually come forward and identify themselves by signing the VDA. If a taxpayer is rejected from the VDA program and they believe a tax does not apply to them, they may also apply for advanced written determination, which we'll talk about next, and or a standard penalty waiver, which will be considered de novo. Once back taxes have been filed and paid, the taxpayer is considered in good standing and the VDA is considered satisfied. Part of the VDA is a requirement to become a registered business for the current year and prior years, up to 6 years. If during an audit, additional amounts are deemed owing, penalties and interest would apply to the unreported or unpaid amounts. Penalties and interest would also apply to any other tax types deemed owed at that time. Now that we've gone through that proposal, I'd like to ask if there are any initial comments on these proposals. If you have a comment, please use the raise hand feature to be unmuted, and we can take maybe about 5 minutes or so total for these comments. And we'll also have time at the end of the meeting for comments globally on any of the 3 proposals.
Hey, David. Hey, Greg. It's Ronnie. Quick question. Are you suggesting that the VDA will only be alive for 3 years? So it won't be a permanent program. It'll just be a 3-year program. Just want to make sure I understood that.
We would start with an initial program of 3 years or some limited time period, and then there would be some analysis over the course of the life of the program to determine its efficacy and the satisfaction of all parties with it. And it certainly may be extended, may not be extended, but most programs have a limited time frame when they start.
Thanks.
Any other questions? And again, written feedback is always welcome as well. I know sometimes it's easier to comment in writing, and so we certainly welcome written comments on these proposals?
All right, why don't we move on to the advanced written determinations? All right, so secondly, our office is considering an advanced written determination process. And I'd like to share the key components to this proposal. First, the advanced written determination program would be authorized for a 3-year period. The subject matter of the advanced written determinations would be limited to apportionment and business activity classification questions. The program would allow any business subject to tax in San Francisco to apply for an advanced written determination by stating relevant facts and proposing a resolution. We anticipate there would be an application window each year and have proposed March 1 to June 30th. We anticipate that we would likely not select any more than 30 cases each year to issue an advanced written determination. Criteria for selection may include, but are not limited to, businesses currently doing business in San Francisco as opposed to planning to do business, issues that pertain to many taxpayers or a class of taxpayers, issues with significant tax or monetary consequences, and first-time applicants. We plan to issue advanced written determinations on a rolling basis and not later than January 31 of the year following when the advanced written determination was applied for. And we do not anticipate issuing advanced written determinations prior to June 30th of any tax year. We anticipate our options for this program will be to request an advanced written, to accept a request for advanced written determination, reject the request, or decline to issue the determination if we do not have capacity to respond to the request. Requests that will be rejected would include hypothetical scenarios. We would be okay with planned behavior, just not hypothetical scenarios. Issues that have been audited by our office for that taxpayer, issues that are outside the subject matter scope, issues that are clear in the law, and issues that other published advanced written determinations have covered. For accepted applications, we will issue an advanced written determination based on the facts submitted by the taxpayer, and any of these AWDs will apply expressly to the facts as submitted. We will also publish redacted AWDs on our website, but remove identifying information about the taxpayer. We intend to send the redacted advanced written determination to the taxpayer at least 5 days prior to publishing. The application signed by the taxpayer or the representative will consent to allow TTX to publish with the business name redactions. We anticipate there will be a nominal application fee to cover a portion of the costs of this program. And we want folks to be aware that this does not preclude any business from being audited and may result in findings independent of the advanced written determination if the facts and circumstances are materially different than what was provided through the advanced written determination process. At this point, we would like to open up and see if there's any comments on this proposal.
All right,
I have one person, Manuel.
great.
Manuel Fishman.
Was that for me?
Go ahead, Manny.
Yeah, sorry.
Thank you for agreeing to publish them. I raised my hand before I saw that, but I'm intrigued by the rolling basis comment. I mean, you understand that we would submit those because they're not hypothetical, because they're planned, on the hope that you don't wait till January 31 of the next year. Am I missing something on rolling basis?
That's correct. We see the same issue, and there's no intent for us to have decisions issued too close to the filing of the taxes for the tax year in question. The rolling base is intended to be a period well in advance of that period of time, potentially in the summertime, when there's an open application period, taxpayers can apply, the window closes, we can then do an analysis of which sort of program, which of the applications we can take in our capacity. And then we would issue, rejections to those we didn't accept, acceptances, the ones we did accept, and then make sure that the taxpayers received those accepted, that the taxpayers received their advice well in advance of the tax filing in February.
And Manny, I just want to also add one thing that's part of the tax reform that's on the ballot for November is that the deadline for applying for an extension is going to be at the end of February, but there will be a significantly longer time for people to actually file their taxes. So the anticipation with this process is that we would have an answer in time for someone to make their extension filing, which also should be less arduous than the past. And then they would still have plenty of time to get together their filings for that filing later in the year.
Did you say whether we can rely? So if taxpayer A files this and you publish it, can taxpayer B cite that or rely on that?
Yes, that is the idea. And again, it would be to the germane facts and circumstances presented. But we want them to be visible to folks, again, in a redacted version, so that we're being transparent and that other taxpayers can take advantage of the advice we're giving to one.
And I would just add, again, like you said, relevant to the facts and circumstances, there could be a situation where a taxpayer believes that their facts are the same, but maybe they are not. And so that doesn't preclude them from down the line being audited and saying, hey, I relied on this that somebody else relied on, but then the auditor saying, well, no, those were not your facts.
Any other feedback? Okay.
We have a couple more, David.
Oh, go ahead.
There you go.
Hi, this is Stephanie Doe with the Council on State Taxation. Can you hear me?
Yes.
Yes.
Hi, Stephanie.
Great. Well, appreciate you having this comment period to discuss about this. Question that I had is, do you have an anticipated time frame between when you have an AWD and when it would get published on the TTX's website?
That's a great question. I don't think we have a definitive answer. I think we would anticipate that we would publish it at the same time that we would send it to the taxpayer. So the taxpayer would get the unredacted version, and then we would publish a redacted version about the same time so that everyone can see it at the same time. We don't know, and we don't know sort of what the sequence of, again, people getting those decisions will be. It could be that I think many will come on a rolling basis during a window time. But again, to Manny's point, we're all very conscious of not wanting to have that window be too close to the filing of the taxes, where there's no ability to really respond and digest it.
Thanks. And my question was posed in relation to the previous comment and question about reliance on an AWD and the impact of that of when an AWD gets released as it comes to the due date for other taxpayers as well.
Yeah, so if I understand your question, if an advance written determination is applied for in, say, June 2025, and there's a decision, a determination issued in, say, November 2025, we would, our plan right now is that would apply for tax year 2025. Is that, and which would be filed, of course, subsequently in 2026. Was that your question?
Yes, that's the timing of it makes the timing of what year it would impact makes sense. But the dissemination of the AWD so that other taxpayers can rely on it the same way as the applicant, that's what I was focused on. So for some taxing agencies, when they do some type of ruling or something comparable to an AWD, there may be a longer lag time between when they actually have it written and when it gets released onto their public website.
I understand. Okay, thank you for that feedback.
Thank you.
Any more questions on AWDs?
We
Comments?
we have two more.
Wonderful.
Nicholas Johnson.
Hi, Nicholas Johnson with Lyft. Pretty simple question I have. Who makes the determination, or how is it determined that a subject is clear in the law? I saw that being one of the limitations of an AWD. So I just wanted to see if you had any thoughts about that.
Yeah, that's a great question. I think certainly I believe I'll be a part of the determination process, and some group of an internal employees in TTX would be a part of this as well. I know that the state of California has a committee comprised of quite a few folks who get together on a regular basis to review the applications and make decisions together. I don't know if what the group will be comprised of, but I would certainly assume that I would like to be part of that group. And in terms of what we would look at, the law on the books as it exists. That's really what we do in all times, is look at the law and make decisions as best we can based on that. I don't know if that answers your question though.
Well, I mean, there's always litigation, and there's always, court cases that could change an interpretation of the law. So I was wondering if that was something that was considered, whether there was a court determination on it, not just the plain reading as.
Oh, certainly. We look at
Yeah.
all of those factors and sort of, we're globally aware of sort of litigation and other things that
Right.
the actual interpretation of the law as well. So.
Okay. Thank you.
Yes, you're welcome.
Okay, we have John Hayashi.
Okay, thank you, John Hayashi. I also have a question following up on the previous question about the depth and breadth of the review process. It would seem like maybe a lot of taxpayers who are unclear of the application of law may find themselves, oh, well, let's just go ahead and do an AWD request, when what they really need is a clear interpretation of the law. Or they have no idea what previous AWDs cover. So somebody in the cities might have to say, oh, this has already been covered, and here are the AWDs that cover that. Is that anticipated as part of that, the substance of that review process? Or is there another part of the tax collector's office that will answer those questions before a taxpayer thinks they need to file an AWD?
That's a good question. We're very sensitive and do not feel it's in our purview or authority to give tax advice. And absent this is our official position way to give tax advice in a limited way. But we encourage folks generally to understand the law, consult a tax advisor if they want. None of this program would replace the need for taxpayers to understand what's on our website, what the filing experience is like, what the gross receipts tax applies to, or whatever tax type we're talking about applies to. This is just intended to be one specific way that we give advice to a targeted universe, and then let everyone know about it so that everyone can get the benefit of that knowledge.
And I'll just add to that, John, if our plan with this is, let's say somebody has a process that is, all four corners or something we've already spoken to in an advanced written determination, we would likely reject that and then and then tell them the reason why is that there was already an advanced written determination on that topic, and probably direct them to review that literature so that they can better understand that.
Very good. Thanks.
Thank you.
And we have Aaron, move on.
Yeah, thanks. Question for you. Why are you guys limiting yourselves to NAICS and David and Craig, this for you guys. Why are you limiting yourselves to just NAICS and sourcing, given that you have the ability to reject it if you don't like it? Is there a specific reason you could share with us why just those two topics? Because I can think of a host of other issues that might not be clear in the law that you might find, you know, determinative or helpful. I'm just wondering why you're restricting yourself, since you're ultimately going to have the power to reject a claim for various reasons.
Sure, good question. Those tend to be, I think, in our estimation, the most common questions that come up in tax collector hearings from taxpayers, and we wanted to at least address the most common questions. We don't know if we have the capacity to address every single question or want to address every single question, but these two, certainly in my experience here, have been routinely brought up, and we thought at least it would give some comfort to have questions answered on those topics. Again, this is also intended to be kind of a pilot program for some period of time to determine, is it working, is it not working? And I think that's certainly one area we could look at. Ron, were there certain areas that you wanted to have included, or what would you like to say more about that?
I mean, the other area that I often see as an area of controversy is what is a gross receipt, and getting your input on that. Again, we'll see what happens with sort of the intangible sourcing discussion, which is, I think, going to be the topic of one of the meetings. But that was the other area that I was thinking of, whether it's a gross receipt or not in the department's estimation.
That's great. Thank you for that.
Thanks.
All right, we have no other hands raised.
Okay, shall we move on? Great feedback. Thanks everyone for all of the information. So finally, this is the area that maybe most of you are most interested in, around sourcing, and we're seeking information on sourcing. There is a more thorough list of sourcing questions that went out in the meeting invitation. I certainly encourage you to take a look at that. We only included here sort of the outlines of those questions. And detailed written feedback on these is also very, very helpful. As you are aware, Code Section 956.1 will be used to allocate at least some gross receipts for most business activities. It specifies rules for real property, tangible personal property, services, intangible property, and financial instruments. Here are the questions that we would love to get feedback from either today or through the next couple of months. First, are there any issues or specific sourcing rules that would be beneficial for any of the sourcing categories in Section 956.1 of the Business and Tax Regulations Code? Second, are there any specific business activities or industries that would benefit from specific sourcing rules beyond the sourcing rules for the types of property and services addressed in question 1? Third, in the event that specific sourcing of gross receipts is difficult or impossible, would reasonable approximation be appropriate in your minds? Next, any thoughts on the Franchise Tax Board sourcing rules, which I know are voluminous? Do you have any thoughts about sourcing rules or rules from other jurisdictions that would be illuminating to us? And finally, any thoughts you have on a safe harbor? What types of safe harbors that would be appropriate in your perspectives? So that's a lot, I know, and for very broad questions, but given that, are there any initial thoughts that people would like to share on the sourcing questions?
We have one, Manuel Fishman.
Sourcing as it relates to real property.
Oh, Manny, I couldn't get the first part of your comment.
I had thought that sourcing as it relates to real property
in a sense, was a narrow question, because in order for it to be a gross receipt, the building has to be in San Francisco. But we had some discussions on this at the chamber, and in light of Iran's question about sourcing,
can sourcing be broad
enough for real property
to include whether something is a gross receipt? Do you see where I'm going? I mean, it's hard.
hard to say. We don't allocate. We have, it's a gross receipt if it's received in San Francisco for a building in San Francisco. And so at some level, we're boxed out of the sourcing discussion, but we believe we do have sourcing questions.
And that's exactly the point of this process. We didn't mean to necessarily exclude anybody from this. And so I encourage you, Manny, to put to tell us what situations and what experiences would be areas where there is an ambiguity or you would like to discuss with us. I think we'd be happy to look at that.
Thank you.
Of course. And this is an area, again, where written feedback, I think, would really be great for us to hear. And again, it'll be confidential. Because a lot of the sourcing questions goes to particular and sensitive concerns about particular businesses. And I understand the hesitation to necessarily come out with hypothetical examples or real examples in a public forum. But certainly we're happy to discuss and listen here or read comments at any time.
We have one more.
Quick question for you guys, and sort of it's more administrative than specifics, but if we have taxpayers who rather than doing written would like to have a discussion, will there be a process on that? Or you?
Well, Ron, you cut out just at the very end, but I think we got the gist of the question, which is, again, taxpayers are certainly free to reach out to our office and discuss. We discuss the mechanics of the tax filing experience, and we try to put everything on the website that we would have to share with members of the public. And so we certainly encourage that. People want to talk to us, they certainly can. I would caution against the expectation of giving, again, tax advice, which we don't feel like we can give. And I know that sometimes can be frustrating for folks to hear that, but that's generally an area where we try to limit our involvement again as giving tax advice, since we are the tax authorities here. Did that answer your question, Aaron?
Sorry, David, I think the system muted me. What I was trying to say is some of the issues they might want some dialogue back and forth to explain nuance that you might not necessarily get from a written commentary. So not looking for advice from you, but make sure you understand factually sort of what they're driving at. I can envision at least one or two of my taxpayers who would want the chance to have that conversation with you. Again, not seeking advice, but make sure they've fleshed out all the facts for specific rules. When I think about what happened, especially from a California interested party meeting, the several meetings where they sort of went in detail and the results of that. Does that make sense? I'm just thinking of the previous process that California had, where they had interested party meetings where some of that discussion took place.
Right, and I think we anticipate that the meetings we're setting up for September and October can maybe replicate some part of that experience and involve some back and forth and hearing about what the particular issues are and how we could maybe address them or not address them through this process. But that's the idea behind this, is to really receive feedback from different people and listen and certainly have conversations when we can.
Understood. I guess what I'm saying is I have some taxpayers who don't necessarily want them. They'd rather keep anonymous when talking to you, and which they might do via the more open forum. So something to think about. Again.
Oh, I see. Not in a public sort of in this type of forum. Well,
Yep.
Certainly, again, I really encourage the putting pen to paper and writing to specific concerns. That really is the best way. And also it takes out the variable of sort of misinterpreting something through a verbal comment, which I think the stuff gets so technical and it's so important to get it right that I worry that giving a lot of verbal feedback could result in a miscommunication. So we really do encourage folks to write to us with their specific concerns.
Understood. Thanks. Appreciate it.
Yes.
We have one more, John Hayashi.
Yeah, one thought that has always been an issue at the state level is the whole possibility of double taxation. So I don't see it in this particular discussion, but what happens if the same gross receipts are taxed by San Francisco and maybe another Bay Area jurisdiction? Taxpayers many times say, well, why am I paying two city taxes? Can I get a credit for taxes paid to another jurisdiction? I'm not suggesting an answer. I'm just saying that I know a lot of taxpayers have that issue, is when I get taxed twice on the same gross receipts by local jurisdictions.
So thank you, John. Any other feedback? And really at this time, we can take feedback on any of the proposals or any global comments people would like to make. Happy to hear them as well.
May have been